It's all over the world. The doctrine of discovery was evil from the beginning, and it's still evil today. That's taken the soul out of Indigenous people when you take their land.
The doctrine of discovery is this fundamental lie that non-Indigenous people can show up, plant a flag, and claim a right to own the land and displace Indigenous laws over the land.
It's a legal fiction. It's not law. It's akin to a country going in and sprinkling magic dust over something, and that gives them ownership to it.
The doctrine of discovery has created the foundation for legal developments where the United States and Canada get to claim lands that were Indigenous lands.
The origin of the doctrine of discovery begins with the papal bulls and the dividing up of the world by the Catholic Church.
A papal bull is a written decree issued by the Pope. Back in the 1400s, there was a series of papal bulls that basically gave Christian nations the religious authority to seize lands and resources of non-Christians and to enslave them. If you've ever watched Disney's Pocahontas, the doctrine of discovery relates to a legal principle known as terra nullius, which is Latin for nobody's land. The papal bulls inspired the idea that anyone who wasn't Christian was inferior, and therefore unworthy of land ownership. So by this logic, the Americas were terra nullius and free to claim.
We were heathens, we were savages, and that attitude continued. It's why we have all of these laws, policies, and regulations and practices that subdue, oppress, surveil, and control Indigenous peoples.
It's this racist principle that comes from the Catholic Church that was formulated in the U.S. Supreme Court, and then it was adopted by Canadian courts.
So while the papal bulls didn't directly create a legal doctrine, it became a legal doctrine through various court cases in the United States.
In 1823, the case of Johnson versus McIntosh was considered before the United States Supreme Court. The case involved a piece of land that was allegedly sold to Thomas Johnson by a Native American tribe. The U.S. later sold that same piece of land to William McIntosh. Chief Justice Marshall ruled in favor of McIntosh on the grounds that the U.S. owned the land. And this decision was based on what's become known as the Doctrine of Discovery.
Chief Justice Marshall, prancing around his home, how am I going to resolve this? And he stumbles on this doctrine of discovery. And he uses that as a legal principle and says the Indians never had anything to sell in the first place.
This was a legal principle between European nations, that whichever discovered a territory first had the sole right of title to the lands. While the court acknowledged Indigenous peoples could use the lands, the exclusive title went to the Crown.
So you can imagine over several hundred years that gets well ingrained into American law, and then it gets incorporated into Canadian law.
There's 3 constitutional cases that you need to know about. They shaped Canada using the logic of the Doctrine of Discovery. The first case is St. Catharines Milling. Back in 1888, there was a dispute over logging rights in northwestern Ontario. Basically, who owned the land? The highest court of appeal at that time ruled that Indigenous interest in the land only existed by the grace or goodwill of the Crown.
So that was bad, but it got overturned effectively in Calder.
The Calder case was in 1967. Frank Calder and other Nisga'a elders sued the BC government saying that the Nisga'a never extinguished their land rights. They appealed all the way to the Supreme Court.
The Calder case acknowledged that, in fact, we have Aboriginal title. We have the right to own our lands. However, it's something less than full ownership, and the Crown has underlying title.
And then, in 2014, there was the Chilcotin case. The Supreme Court of Canada declared that 1,700 kilometers of tidal lands belong to the Chilcotin Nation. It was the first time that the Supreme Court of Canada declared Aboriginal title to a specific parcel of land.
You have the Supreme Court of Canada officially denounce that there was any concept of terra nullius or that these lands weren't inhabited. However, that's not the end of the story, because if you take all of the case law in Canada that deals with Indigenous land rights, Aboriginal rights, treaty rights, any rights whatsoever, you always see the Supreme Court of Canada or any other court support this idea that Canada, of course, naturally has title, naturally has sovereignty over all of these territories, and what we have is something less. We have the right to use it, to occupy it, but never that underlying title. It's always presumed to be vested in the crown.
St. Catherine's Milling case means as much today as it did when they first decided it in 1888. Our Court of Appeal just recently used it as precedent for denying ownership of land or denying certain rights to First Nations.
So a lot of Indigenous peoples, especially those that went to Indian residential schools, have been lobbying the Pope for a long time to rescind the papal bulls.
In March of 2023, the Vatican responded to Indigenous demands and formally repudiated the so-called Doctrine of Discovery. But what does that really mean?
I think it's important politically. Keep in mind, Catholic Church ran the majority of Indian residential schools here in Canada, and that's important for people's healing. What's the impact in law? Nothing.
In his repudiation of the Doctrine of Discovery, the Pope claims that it was never the Catholic Church's intention that anyone would go and claim lands or create legal doctrines based on the papal bulls.
With all due respect, I don't think that's the case. You don't send Europeans to go forth and steal lands unless you actually mean it.
That being said, is the battle really with the papal bulls from hundreds of years ago? Or is it with the current Canadian legal system?
We always look somewhere else for change, but the Pope has nothing to do with us. We need to change our own laws.
You can imagine the United States and Canada don't want to do this. This is absolutely fundamental to their ownership of all of the land. They're not going to give that up easily.
Non-Indigenous people say, oh, my family's been here for 2 generations, 3 generations. That's nothing compared to the Indigenous people who have been on those lands for thousands of years, thousands and thousands. That history ends up being denied and devalued, and then it puts Indigenous people on a back foot, because then they're forced to go into a Canadian court, into a colonizer court, and defend themselves. That is a really an immoral situation to put them in, and that is unfortunately at the basis of the relationship between Canadian law and Indigenous people.
Canada made the choice to engage in Indian residential schools and steal children. Canada made the choice to allow them to die or be murdered or sexually abused and not help these kids. Canada made the choice to forcibly assimilate Indigenous peoples, to issue scalping bounties, to forcibly sterilize women. All the acts of genocide that they've been found guilty of, these are all choices. They're not saying, what would the Doctrine of Discovery tell me to do? No, at that point, it's their vested economic, political interests that they're trying to protect. Their power, their wealth, and everything that has to do with Indigenous peoples, effectively try to get them out of the way.